Hello friends, in the series on income tax cases, today we will discuss a very important case in which the assessing officer made an addition on estimation basis of 1% of the total purchases without rejecting the books of accounts. The issue before the Honorable Tribunal was that whether the addition can be made on estimation basis without rejecting the books of accounts, and the second issue was that can the CIT appeal enhance the addition without making any further inquiry or without bringing any further material on record. These two issues have been decided by Honorable Kolkata ITAT D bench in the case of Rainbow Vanijay Private Limited versus Assistant Commissioner of Income Tax, and this case is reported in 136 ITR Tribunal at page number 360, and the date of the judgment is 31st December 2025. The facts of the case are like this. In the present case, the assessee is a trader in steel and other items, and the assessee is doing his business as a pacca arhatiya. The modus operandi of the business of the assessee was that the assessee was purchasing the goods and selling the goods, and these goods were delivered directly to the purchasers, and even the payments were directly settled between the purchaser and the sellers, and the assessee was earning his commission. But the assessee was showing the purchase and sale in its own books and was earning a margin of 1%, and the books of accounts of the assessee were audited under the Companies Act and under the Income Tax Act under section 44AB. At the same time, the assessee was also registered with the GST department and was filing the GST returns and was maintaining the purchase bill, sale bill, and all these documents were provided during the assessment proceedings also. During the assessment proceedings, the assessee was showcaused that why the total purchases should not be added into the income of the assessee as bogus purchases, and another showcause notice was issued suggesting the addition of 1% of the commission income, alleging that the assessee is also dealing as an accommodation provider. But the assessing officer ultimately restricted his addition at the rate of 1% of the total purchases as commission by treating the assessee as an accommodation entry provider. The amount of addition was near about 1.33 crore, and when this matter came before the CIT appeal did not make any inquiry. The CIT appeal did not bring any further material on record, and just on the basis of the showcause notice issued by the assessing officer increased the addition and made the addition of the total purchases of the assessee by increasing the addition by 66 crores. The assessee filed the appeal before the tribunal, and when the tribunal heard the matter, first of all the tribunal said that whatever the addition by the assessing officer has been made on the basis of estimation basis at the rate of 1% is not justified, because the learned assessing officer has not rejected the books of accounts under section 145 subsection 3, so the estimation of income cannot be done by the assessing officer. At the same time, the tribunal said that in the present case, the assessing officer has failed to make any inquiry under section 142 subsection 1, and the CIT appeal has gone further, and whatever the addition has been confirmed or whatever the further addition has been done by the CIT appeal is not justified, because he has not brought any further material on record and he has not made any inquiry. The tribunal also said that the CIT appeal has not doubted the sales of the assessee, so doubting the purchase is also not justified. So in the present case, the total addition of the purchases which has been done by the CIT appeal was also deleted by the tribunal, and even the addition on the percentage basis was also deleted on the ground that the assessing officer has failed to reject the books of accounts on the reasonable reasons. Friends, this case is very important because it is seen that in very routine matters, the assessing officers make addition for the sake of making the addition on the basis of some estimation or some percentage basis, and they forgot that there is a principle of rejecting the books of accounts before adopting the estimation basis. So this is a very important and eye-opening case for those cases where the additions have been made on the estimation basis without rejecting the books of accounts. At the end of this video, once again I am repeating the name of the case. The name of the case is Rainbow Vanijya Private Limited versus Assistant Commissioner of Income Tax, and this case is reported in 136 ITR Tribunal at page number 360, and the date of the judgment is 31st December 2025. Thank you, friends.